Today, the Trump Justice Department released more than 3 million pages of documents from the Epstein files, which seems like a lot of documents, but it's reportedly only half of what the Justice Department actually has.
Donald Trump and the Department of Justice just made it clear right now that they intend to withhold approximately 50% or half of the Epstein files, while claiming to have fully complied with the law. This is outrageous and incredibly concerning. Now, the Oversight Committee subpoena, which we have had in place now since the summer, had directed the Attorney General, Pam Bondi, and the Department of Justice to release all the files to our committee, of course, while also protecting our survivors. They are now in violation of that law.
Now, the two lawmakers who worked tirelessly with survivors to pass that Epstein Files Transparency Act, the Democrat Ro Khanna and the Republican Thomas Massie, sent this letter to Todd Blanche tonight, the Deputy Attorney General, with demands for the specific material that they say the Trump DOJ has refused to release. Quote, as the bipartisan lead sponsors of the Epstein Files Transparency Act, we write to formally request access to unredacted documents of the Jeffrey Epstein files, given ongoing reported concerns regarding the scope and consistency of redactions in the documents released to date. We respectfully request a meeting to review the unredacted records. In particular, we seek access to the following categories of materials. First, hundreds of thousands of pages of emails and other documents recovered from Jeffrey Epstein's email account during the 2018 and 2019 investigations into Epstein and Ghislaine Maxwell. Secondly, victim interview statements from the initial Florida investigation and subsequent investigations in New York. We understand that the department possesses FBI Form 302 reports documenting these interviews. However, the materials released to date in this category consist largely of pages that are fully redacted, providing no meaningful information for oversight or public accountability. Third, the 53-page draft indictment and the 82-page prosecution memorandum prepared during the 2007 Florida investigation. These documents are essential to understanding the government's knowledge of Epstein's criminal conduct and the circumstances surrounding the non-prosecution agreement and immunity that he received. End quote. All right, joining us now to make sense of all is MS Now senior legal reporter Lisa Rubin. Lisa, I want to start by saying that the Attorney General, formerly Trump's lawyer, Todd Blanche, says you got everything. All you don't have is stuff that was redacted because of protection of the identity of victims.
Yes, and he also said earlier today that one of the things that the Department of Justice had withheld entirely were things that had privileges attached to them. Things including attorney-client privilege, work product protection, and something known as deliberative process privilege. Put in layman's terms, that means internal deliberations of the Department of Justice. He also said during a point in his press conference that in addition to the 3 million documents that they dumped on us today, oh, guess what? There are another 3 million of them that they didn't produce.
Right.
So not everything that they withheld was for the privacy and safety of victims. In fact, we know that, Allie, because one of the things that characterizes their production today is a sort of rampant sloppiness with respect to actually protecting that information. And to that end, if I can, I'd like to read a statement that I received tonight from the victim's lawyer. I noticed today I counted almost 20 victims' names that I personally recognized just in the cursory review that I've done so far. I also saw the driver's license of a particular victim that I recognized with her face and her name fully visible. That is contrary to the promises that Deputy Attorney General Blanche made today. So I contacted a lawyer and I asked what her thoughts were on this. And this is the statement I got from Brittany Henderson, who is the partner of Brad Edwards. Together, they represent quite a large assortment of Epstein survivors. She wrote, what the Department of Justice has done today is devastating and disgusting. Through this final release of documents, the department has flagrantly violated the trust, privacy, and the rights of more victims than perhaps ever before.
Wow.
The department has been in possession of a comprehensive list of victims of Jeffrey Epstein for months. In that time, they have spoken directly with several terrified women who they promised to protect through a fulsome redaction process. Their complete and utter failure to do so is heartbreaking. There are not words to express the disappointment. And again, that's a statement attributable to Brittany Henderson, one of the lawyers who represents some of the most outspoken Epstein survivors who have advocated for not only the passage of the Epstein Files Transparency Act, but have repeatedly pressed for compliance with the act, compliance that we really didn't see today in a variety of ways.
And by the way, this idea of protecting the survivors is important across the law as a legal principle. But in this particular case, these are survivors who are saying that there are some remarkably wealthy and powerful people who might be implicated in this thing. For them to inadvertently have their names, some of them have gone public, but for them to willy-nilly have their names out there, it's a substantial threat. It's not an abstraction.
No, it's not an abstraction at all. And I read today, you read from that letter from Congressman Khanna and Massey, where they are asking for the department to produce what are called FBI 302s. That is the form that the FBI types up victim statements into. And they are right. There aren't a lot of them there. But which ones are there? I saw one today where at the very end of it, this was from a 2021 interview of a survivor. The last thing she said was, Ghislaine Maxwell is sociopathic, and I fear for myself if she is not convicted. So there are legitimate fears on behalf of many of these survivors, not just about the people we do know about, but with respect to others that we don't as well.
Help me out with the stuff that we've heard from Robert Garcia and from Thomas Massey and from Ro Khanna about what's not there. How do they know what's not there?
Well, I think there are ways to search this, right? So DOJ was compelled by law not only to produce to the public, but to do so in a way that was text searchable to all of us. So you can enter lots of words in this search and come up with documents. If you're looking, for example, for that prosecution memo or that draft indictment, two of the things that are most important to Massey and Khanna, and frankly, to me as well, you can see whether they are there if they come up in a search. One of the ways also that I knew that they were so sloppy with their redactions is because I looked for the names of particular victims and I found them. So it's not that we've done a thorough boil the ocean review of the 3 million pages we've seen so far, but that there are ways of searching these documents. And of course, there are lots of people looking at them. If you look at Twitter today, the assortment of various media outlets that are looking at these and collectively sort of finding bits and pieces here and there, you can compose sort of an aggregate picture, at least initially, of what people consider to be the hottest documents and also the most egregious absences.
So where are we now? Because Todd Blanche has basically said, he stated reasons why, but he said we've fulfilled our requirements under the Transparency Act. Ro Khanna, Thomas Massey, Robert Garcia say otherwise. What happens now? We saw the letter that Ro Khanna and Thomas Massey have written to Todd Blanche, but what happens here? Because Todd Blanche has said he wasn't equivocating about this. He said you've largely got what you're going to get.
Well, there are two things. One is they haven't gotten everything that they're entitled to because under the law, they have a legal obligation, they meaning the Department of Justice, to produce a report within 15 days to Congress that talks about the categories of documents that have been withheld, the categories of redactions, the reasons they've redacted documents, and they're also supposed to provide a list of all significant people that appear in it, including government officials. So that information still needs to be delivered to Congress. With respect to what comes next, though, I think what you're driving at is what remedy is there for Congress to the extent that there has been a lack of compliance here. And here's where I wish that Robert Garcia and Ro Khanna were with us right now, because I'd put that question to them. Where I read the law, I don't see a legal remedy for Congress to sue, for example, for better compliance or enforcement with the Epstein Act.
So notwithstanding the fact that Congress overwhelmingly voted for this Epstein Act, the power of a bipartisan unified Congress isn't enough to overcome the Department of Justice not doing what you evaluate they're supposed to have been doing?
Well, I mean, I think one of the questions is, does Congress want to hold anybody in contempt for failure to comply? They could refer somebody to, guess what, the same Department of Justice that they're accusing of noncompliance. But from a legal perspective, let's say they wanted to bring a lawsuit. One of the challenges is this really fundamental legal concept called standing. It's who has the ability to sue. And over again, courts have found that individual members of Congress, even sometimes whole committees, don't have the right to stand in the shoes of the entire Congress to sue to vindicate rights that belong to them as an institution. So unless the Speaker of the House and the majority leader of the Senate want to convene some sort of resolution where both bodies vote to sue, there likely would not be standing, which is like one of the most elemental things you need to sustain a lawsuit in the first place.